Good afternoon, everybody. It's a real pleasure for me to get to introduce this very distinguished panel. We'll be discussing the issues of AI and the law. And our first panelist is Brad Smith. He's the Vice Chair and President of Microsoft, where he leads a team of 2,000 business, legal, and corporate affairs professionals located in 54 countries. I believe he's currently in one of those countries, doing by video. He joined Microsoft in 1993, first spending 3 years in Paris, leading the legal and corporate affairs team in Europe. In 2002, he was named Microsoft's general counsel. He was previously a partner at Cummington & Burling, where I'm told he was the first attorney in the long history of that firm to insist on having a personal computer on his desk. He is the co-author of the best-selling book, Tools and Weapons, The Promise and Peril of the Digital Age. He attended Princeton University and Columbia University Law School. Here in Seattle, on your right, Mariano Florentino Cuéllar is the president of the Carnegie Endowment for International Peace. He was previously an associate justice of the Supreme Court of California. His long career in public service also includes being a part of the White House Domestic Policy Council in the Obama administration and the Treasury Department in the Clinton administration. He was a member of the faculty at Stanford University for 2 decades, where he served as the Stanley Morrison Professor of Law. He's also served on the National Academy of Sciences Committee on Social and Ethical Implications of Computing Research. He attended Harvard College and Yale Law School and received a PhD in political science from Stanford. And on a personal note, I will add that his wife, Lucy Coe, is one of Judge McKeown's and my new colleagues on the Ninth Circuit with their chambers in San Jose. Last but not least, our moderator is Judge Margaret McKeown, who was appointed to the Ninth Circuit in 1998, maintains her chambers in San Diego. She was a White House Fellow, serving as Special Assistant to the Secretary of the Interior and the Special Assistant at the White House. She was the first woman partner at the Perkins Coie firm here in Seattle. She has lectured and taught on constitutional law, international law, intellectual property, litigation, and ethics. She's a member of the American Academy of Arts and Sciences and the American Law Institute. She attended the University of Wyoming and Georgetown University Law Center. So please join me in welcoming our panelists.
Welcome to our program on artificial intelligence. It is a timely topic. A quick news search shows that the term AI or variations on the theme were in major news outlets more than 50,000 times in just the last week. To set the stage, I think it will be helpful to have a few definitions. First, what is AI? AI, or artificial intelligence, is the development of computer systems capable of performing tasks that typically require human intelligence, such as understanding natural language, recognizing patterns, learning from data, making decisions, and solving problems. What is generative AI? Generative AI refers to a subset of artificial intelligence focused on creating new content or data rather than just analyzing or interpreting existing information. It involves algorithms and models that can generate novel outputs such as images, text, audio, or even entire simulations based on patterns learned from training data. Generative AI has applications in various fields, including creative arts, content generation, data augmentation, and simulation. I know we hear a lot about ChatGPT. Are there other generative AI programs? Yes, there are several other generative AI programs besides ChatGPT. Some notable examples include OpenAI's DALL-E is a generative model designed to generate images from textual descriptions. It can create images based on text prompts, allowing users to describe concepts, scenes, or objects and generate corresponding images. Deep Dream, developed by Google, is a generative neural network that creates visually hallucinatory images by amplifying and modifying patterns found in existing images. It demonstrates the potential of generative models for artistic expression and visual exploration. StyleGAN, developed by NVIDIA, is a generative adversarial network architecture used for generating high-quality images. It has been particularly successful in generating realistic human faces and other visual content with diverse styles and characteristics. ChatGPT, while known primarily as a conversational AI model, GPT, which stands for Generative Pre-trained Transformer, is also capable of generating various forms of text beyond conversation, such as articles, poems, code, and more. In the interest of full disclosure, you should know that I did not record this introduction, nor did I fashion the definitions. The definitions come from ChatGPT. The voice is the product of an AI program that simulates my voice. So now back to the real me and our wonderful panel.
So here we begin. That was done through an AI program that took my voice off of the internet and then created this introduction. We, of course, had to get some definitions from ChatGPT and various other sources. But it gives you a sense, we thought it would give you a good way of thinking about AI when you realize that it sounded like me, but that definitely was not me. And over time, we trained it a little to be a little more expressive, but it never was perfect. So it's our pleasure this afternoon to talk with you about AI, and I'm happy to have this panel here. Tino, whom I've known since he was a law clerk on the Ninth Circuit, and Brad, who I knew long before he was an executive. He was, as we say, just an attorney like all the rest of us. He's now appearing in some undisclosed location, far, far away, but I think it's the middle of the night. So I really do appreciate his coming. I wanted to start with a short comment by Isaac Asimov. He said the only way of discovering limits of the possible is to venture a little way past them into the impossible. Any sufficiently advanced technology is indistinguishable from magic. So with that, I would like to start with our panelists, and I'll start with Brad to say, well, is AI magic? Is there an analogy as far back as the printing press or other analogies so that we're not just thinking of the impossible? And kind of roped into that question, which would be objected to as a compound question if I were in the district court, but it is the fact that we want to know what the future holds in AI and what can we learn by looking back at the internet.
Well, let me begin, and actually greetings. I'm in Abu Dhabi, where it is a little before 3 a.m. But it's great to be with all of you in Seattle and up and down the West Coast. And I was in Tino's office about a week ago today in Washington, D.C. So nice to be back with you as well. It's not magic, it's math, is a short way of thinking about it, because fundamentally AI is at its heart a series of algorithmic equations grounded and based on an enormous amount of data. But I really do like the analogy to the printing press. And there's a couple of things worth thinking about. In the world of technology, there are general purpose technologies and specific purpose technologies. A great specific purpose technology is a lawnmower. If you need to cut the grass, you want to have one. But if you want to do something other than cut the grass, a lawnmower is not very useful. But AI is like the printing press first, because I think it is a general purpose technology. It will be used to pursue a wide variety of things. I actually think it's like it's like the printing press as well, in that I think it really connects to the life of the mind. Perhaps, in my view, as much as any invention since the printing press, which was in about the year 1450. Fundamentally what that enabled people to do, obviously, was to write and reach people and enable other people to read. And it just opened the door to so much. And I think we'll find that AI is a tool that serves intellectual pursuits in a similar way. A second respect in which it's similar to the printing press is this. As we say in the tech sector, most general purpose technologies sort of have a tech stack. And what that means is it actually requires a variety of technologies to come together in order to be useful. A printing press, obviously, when you think about it, it required enormous advances in the production of paper, the production of ink, the production of movable type that could be produced in large quantities. And then it required a new thing called book binding. And then it required new companies that were engaged in selling. All of this needed to come together. And in a similar way, what we're seeing with AI is a stack of technology. It really starts with a lot of computing resources in large data centers. They need land, they need a lot of electricity, they need water, they need chips. That's why you read so much about NVIDIA. They've got the chip that is the most important right now in AI. They need data, and out of all of that, somebody can create what's called a foundation model, like GPT-4, for example, that's trained in that data set or with that data. And then once the model is complete, it can be used by applications. They call on the model to answer questions, to produce results, and ultimately, like the readers and writers, there are users that all of this is meant to serve. I would then just say there's one last aspect that is just worth thinking about. One of the real lessons of the printing press, in my view, is that in some ways what matters is not just who invented it, but how the technology is diffused. And Johannes Gutenberg invented the printing press with movable type in the western part of Germany. But the Germans actually, when we go back and study it, were not the fastest adopters of the printing press. The part of Europe that put it to the work most broadly, most quickly, were actually the Dutch and the Belgians in the Low Countries. And in some ways, what happened was extraordinary, because before the printing press was invented, humanity had only produced 8,000 different manuscripts in 1,000 years, meaning 1,000 different works of literature. But by 1500, humanity was producing 1,000 new works of literature every 5 years. And before the printing press was invented, you would have to travel through Europe, and you would literally have to shake 500 hands of different individuals in order to meet one person who had read anything in the year before. But in the Netherlands, by 1500, on average, every other person was reading something. So how did this little country, barely above sea level, become so economically successful? They read more books. And I think that is an incredibly powerful lesson. The Dutch grew their percentage of European GDP by under 7% to over 11 in only 50 years. And that printing press, just think about what it produced. The Reformation, the Renaissance, the Enlightenment, the scientific method, the spread of democracy itself. I think in so many ways, it grounds us in how we should think about what AI can bring. It will get better and better. And Tino can talk about this as well or better than me. The technology is advancing rapidly. But in so many ways, what really matters is how it's put to use. What scientific or other endeavors is it used? Can it spread around the world more rapidly so it supports the world as a whole? Can it support underprivileged communities in the United States? Can it be used by everyone in a way that fundamentally the printing press was not? These are all some of the questions that I think are really very important for our next 50 years.
Well, that really brings me, as Brad left it, how is it going to be used? And there's a lot of hysteria in the press about AI will eat your job and that sort of thing. If you think back to the internet and when it became really more used, the concern was that we should leave it to private oversight and not have the government get in the way of progress and in terms of development. But ultimately, we do, of course, have some government regulation of the internet. And I'm wondering, Tino, if you can contrast that with AI, where now everybody's clamoring for regulation, although nobody's agreeing on what that would look like.
This is true, and thank you, Judge McKeown. And Brad, it's always good to see you. I guess I can say that I'm staring at a camera, so I'm not quite seeing you, but I know you're there. And it was great to see you a few days ago. And Judge Miller, thank you for the introduction. When you were introducing me, I was reminded of an interaction with my son, who's a teenager, when I was appointed to the Supreme Court of California. He said, "Dad, why couldn't you be on the real Supreme Court?" And I thought I was through with that phase in his life when I became president of the Carnegie Endowment, which, if you're wondering what it does, Andrew Carnegie created us 113 years ago to advise policymakers using objective, independent research, support diplomacy, to see how the world could have less conflict and more cooperation. He said, "Dad, I just want you to know none of my friends have ever heard of it." It's probably true in this room too, to some extent. I want to highlight something that Brad said before getting to Judge McKeown's question. Brad talked about how important it is to understand how this will be used. The thing about a general purpose technology, a technology that will allow us to automate some of what made humans the masters of the planet, our intelligence, not our strength, our intelligence. That, to my mind, is the key to understanding what society we will have. Who will use this to create disinformation, to try to develop a cyber exploit that might have been a lot harder to do at a team of 10 or 12 or maybe 10,000 people working before? Who will use it instead to close the justice gap that we all as lawyers know continues to bother us and really create a real blemish on the American legal system, how hard it is for a pro se litigant to navigate the court system, as a state trial judge, not a trial court judge, but a state judge, and found myself visiting courthouses and realizing that so many of the lofty ideas we had about justice when we read an opinion on the Supreme Court of California would get lost in translation when it came to actually somebody showing up at the courthouse, saying in a language other than English that they needed a form to try to get a restraining order because they were in fear of their safety. So when I think about those challenges, when I think about the number of people around the world who, despite our best efforts, lack a good doctor, a great teacher for their kid, a lawyer, I would like to think that our ability to turn atoms and electricity and data and algorithms and math into intelligent answers will help us close those gaps. That said, I do think another analogy here that is a little bit imperfect, granted, just as the internet is an imperfect analogy, though quite entangled with modern generative AI. Another analogy is fossil fuels. Now today, if I say fossil fuels and you're trying to autocomplete the sentence, something not great would come to mind. But let's pause for a moment and recognize that everything in our built environment, the plane that brought me here from Northern California, this building, the material of the walls, all of that is some pharmaceutical products are deeply entangled in the fossil fuel economy. So much so that weaning ourselves off it right now is pretty challenging. But if somebody took me back to when my organization was created in 1910 and said, Tino, you can wave a magic wand and prevent humanity right now from ever using fossil fuels, I would not hesitate for a moment to say no. I cannot imagine a path to eliminate a lot of the human poverty that is all over the world right now, so completely normal in life, without some way of burning up these fuels. Now, I hope that we'll be wise about how we do it, and I'll just end on the point about the regulation piece. That as we reach the limits of what we can expect good human judgment or responsible behavior from the private sector do by itself, that we're going to have some way of solving a collective action problem. That we'll be thinking about the particular matter that gets into the air that'll make us sick. We'll be thinking about what ultimately this will do to the atmosphere, how that might affect developing countries. And that has taken us far longer than I hope it will take an AI. But I do think the core thing that I want to leave you with, which I suspect Brad and I would not disagree on, would be we have to do that smartly, recognizing that the way forward is generally one that allows for a lot of innovation and gets us to think carefully about what can be done in ways other than just a very detailed governmental regulation. So when people ask me about this, I say, let's start by recognizing you don't need to reinvent the wheel. You have the tort system, for example. We have like elaborate laws that the FDA administers that will get you to the answer of like what constitutes a medical device. And that will often solve some questions around how AI and the medical system should intersect. And then when we have to go a little bit further, we should just be careful to keep it flexible enough that there's a degree of innovation that gets built in, while we are mindful of things like, what happens when people who really have nasty intentions take the next few generations of generative models and want to build a biological weapon with it. That, I think, is going to take a lot of collaboration and careful thinking, not just in government, but also in the private sector.
Let me just follow up a little bit when you're talking about what kind of guardrails, if you will, that you want to put onto AI. At one point, you had proposed that we have a national registry for large AI models. What did you have in mind?
Well, certainly not a licensing scheme. That's important, right? So, because I get questions about this, and people say, like, well, why would you want the government licensing who can use AI? I said, that's not what my co-editors and I suggested, because I thought maybe I said something that was a little troubling, and we lost a participant, but I think not. But instead, the idea is the following. Let's suppose that we can look at the most responsible behavior from the companies that are at the frontier right now of AI development. So I think of to my mind, very beneficial action among some of the companies, including, say, OpenAI, to do a model card, to red team these models and see how you can use them to do something not great. That kind of behavior, which to my mind is very socially responsible, is not necessarily hardwired by law right now. And if we wanted to know who might be about to deploy a very sophisticated frontier model and has not done that, has chosen not to do some testing of the model, some sense of where the parameters, begin to give you problematic answers. It's nice to know who's doing the training, right? And I think some questions arise about how sophisticated the model has to be before you do this. Also, some questions about what can or should the government be allowed to do with that information. But I do think a lot of the happier stories that I'd like to tell myself about how AI can benefit humanity run through the ability of society to make sure that bad actors don't get a free pass, right? And that starts with getting some very basic information. So that's what I think we have. Who's a bad actor?
Yeah, and if I could maybe jump in on that for a moment, I would just build on what Tino said. I mean, first of all, I completely agree that we need a level of law and regulation around this technology. And we should probably reflect on the fact that most markets are regulated in some way. You go to the grocery store and you'll see whole milk and skim milk and soy milk and chocolate milk, and everybody knows it's safe milk because there are safety standards and inspectors. And what is probably, in my view, the most remarkable about digital technology in some ways is that it's frankly gone unregulated for so long. And so one of the things that I just find, not just across the country, but around the world, is people in government, judges, legislators, they say, we're not going to let that happen with AI. And more than anything else, they then talk about social media and the lessons learned. So then there is this focus, as you pointed out, well, then what are we going to do? And it does start, I think, increasingly in a number of countries with a requirement that if you're going to build a model of a certain capability, people call it, frontier models, there are certain requirements that you need to meet. It starts with, frankly, letting the government know that you're going down this path. And under the White House executive order from last year, if they send you a questionnaire and you are developing a certain type of model, you need to fill it out and return it. We got one at Microsoft and we just returned it, I think, about a week ago. And what it addresses is a lot of what Tino said. It in many ways, it is about safety. Do you have the right security precautions that are being put in place so that while the model is being developed, you have confidence that your technology is not going to be stolen, it's not going to be diverted, it's not going to be misused by bad actors, including those who might want to use it to create the next pandemic or you name it. And you'll see, I think, a level of safety standards that will emerge over time that will, in some objective sense, define the safety precautions that need to be built in place one way or another. And what we're also seeing is the US do this in close coordination with the UK and increasingly with the European Union. And my guess is we'll probably see, hopefully, a level of interoperability so that we don't have to fill out questionnaires from 192 countries, but maybe we can fill out one and they can share it, and we'll have a common framework to protect safety.
So I think one of you has referenced the White House executive order. The White House came out with AI principles, but we don't have a national AI law, if you will. So I do want to ask Brad about the whole global situation that you intimated with Europe. Europe has actually passed the European Union AI Act. And so it is tantamount to legislation. We've been through this before with European privacy, where, of course, we have no national privacy law except in certain sectors, health, banking. But you can't go to the great US code and find the privacy law. You can in Europe. And so we spent 16 years back and forth with Europe to try to get a mutual approach. And Europe drove what has become the US approach because it got there first. So Brad, I'm wondering, with the European Union already getting this AI Act passed, whether Europe will be driving, what these guardrails will be, or will the United States be able to keep parity with that?
I think the answer is yes. And what is happening right now in the field of international relations is fascinating and in many ways, in my view, a story that's not being all that widely told and hence not all that widely understood. Europe has something very tangible. As you said, they passed the AI Act. It's more than 200 pages. It applies first and foremost to applications, whether it's ChatGPT or a health application or a banking application that uses AI. And it's very focused on protecting the rights of citizens and consumers, whether it's the right to privacy or to avoid risks of, say, financial fraud or misleading conduct, you name it, a lot of traditional rights. Interestingly, the US had a response last year that started not quite with the same set of issues, but more fundamentally focused on safety and security, transparency, trust, and the like. And it zeroed in on the new technologies, these generative AI models that you defined early on. And the White House pursued a really interesting approach, in my view. They started by bringing a small group of companies together, only 4: Microsoft, Google, OpenAI, and a company called Anthropic. And they basically didn't tell us what to do. They said, this is this problem, and if you all don't come up with some solutions, people are going to get very dissatisfied. So they literally gave us about 4 weeks to propose some steps, some voluntary commitments. In the Seattle area, we at Microsoft rolled up our sleeves. We were the first to hand in the work paper. And then the next day, I had a call with the Secretary of Commerce and the head of the Office of Science and Technology Policy at the White House. And they said, congratulations, you're the first to hand in your paper. You get an incomplete because you need to do more. Now that you've shown us what you can do, we're going to push you to go farther. And it was, I thought, a pretty clever way to move fast with a technology that was so new. So the 4 companies had these voluntary commitments. They all were in by the end of May. And then in July of last year, the White House brought together 10 companies to endorse the White House voluntary commitments that they wrote based on what they had learned. And then from the White House voluntary commitments, they produced the executive order. But what's really interesting is what they also did is they went to the G7. And last year, when the Japanese government was leading what they called the Hiroshima process, they basically took the White House commitments and fashioned it into international guidelines for safety and security and the like. So suddenly the US had a process that brought together Japan and Canada, the United Kingdom, as well as the major countries in the EU itself. And then that influenced what is in the AI Act, at least the part on generative AI. So if there is a competition in the world for who can create regulation and move it the fastest, and you can debate whether that's a good or bad competition. Right now in Germany and France, they're not quite as excited about how far Brussels is going as they were a year or two ago. But the US is not going to cede this to Brussels the way it did for privacy. That is another lesson that's been learned. And it's a very effective response, to be honest.
Can I just build on that for a moment? So I think that's very well put, Brad, and I would add that one interesting thing about the scenario of how the US has gone from some degree of collaboration with the private sector to come up with some principles, straightforward things like test your model before it gets deployed, to G7 principles is that it doesn't resemble the textbook approach to how international cooperation occurs. There's no treaty, there's no formal agreement, but there's an organic process that takes account of differing needs. And I would note that, again, to the point about the comparison of privacy, when GDPR was promulgated by the EU, there was a lot less agreement.
That was a privacy protocol for Europe.
And it raced ahead in ways that not only reflected the fact that there wasn't a counterweight to it, the way there is here, but also, frankly, the fact that people hadn't yet had full experience with it. I do think one of the reasons why Germany and France have a somewhat divergent view inside the EU about just how far to go in imposing limits on generative AI is because of I could call it almost a global backlash to the GDPR. It's sort of viewed as a little bit bureaucratic and not ideal, although some principles behind it might make sense to a lot of people. So I think this is all changing in real time, but I do think the US approach has got some leverage to it.
So, I mean, our sense then is that we're not standing back. We're not going to let Europe drive it like Europe drove privacy. But there's also been a lot of backlash about how much we've regulated or not regulated the internet. So how does that fit with your idea of this national registry or some kind of protocol or principles to impose regulation without calling it regulation?
So I'm going to start by just making two disinterested observations. The first one is that the particular political conditions that obtained in the US to get Section 230 basically protect, let's call them internet platforms from liability for content posted, are not coming to pass with respect to AI. So the likelihood, as just a practical observer, that there would be some kind of federal preemption of, say, state tort law feels far-fetched. And we can go into why that is, but I think a short answer of why is that the landscape of what the internet is and how it works is complicated, it's messy, it's not an ambiguously positive win for policy, although it had its moment. The second observation I would make is reflective of conversations I've had with policymakers, let's say in emerging powers, countries in the developing regions of the world. From their perspective, how the internet is played out is not super benign. They would much rather see a world where some of the amazing technological innovation that has been made possible by the internet is a little bit more under their control, and exactly how that intersects with American interests, with economic growth, with international trading regimes. It's complicated, but I do think it means that once these countries get organized around AI, they're beginning to, the conversation is going to move from sort of that G7 broad principles, largely reflective of the White House, to see sort of how many of those big critical G20 countries like Brazil, Indonesia, India can be, in a sense, brought along and sort of made to see a world where their own interests will also be represented in whatever global approaches they.
Go back to Section 230, which was, basically a law enacted somewhat early in the whole development of the internet, because the policymakers felt this interest and push, if you will, to do something to make sure that the internet would flourish. So it's basically a law that gives immunity to certain internet platforms for information that somebody else, a third party, puts on it. So if you put something on Facebook, which all of the teenagers and others tell us nobody uses anyway anymore, But that means that Facebook would probably get immunity because Facebook didn't put it on there. What happens when you can take an AI tool and then change it?
Well, so yes, I would say there are a couple of layers to that. So one would be, what happens when you liquefy the whole internet, let's put it that way, and you combine it with a particular approach to compute and training and electricity and effectively turn it into a generative model. And now that generative model is telling you something about Judge McKeown, trying to replicate her voice even without your permission.
Without my permission.
And like, what gives? And I think the reality is that for people who follow the common law, this audience, you know that however imperfect our system is, and it is imperfect, we talk a lot about that, it's not designed for any one technology, just for the printing press, or just for fossil fuels, or just for the internet. It's adaptive. That's the nature of the common law. So some of these disputes will end up in the common law system. But then the other point, which you're alluding to, which I think is really interesting, is let's say there is a company that wants to not only build an AI model that's really sophisticated, spits out really intelligent sounding text, and they decide to make the model weights public, open source, open access. So that somebody else can build on that, prove it, and so on. They get, in exchange for that, good press, knowing that others are using that model. What happens to that company that decided to put that model in the open source environment? If it's then used, that model will do something pretty awful to somebody. Figure out some way to infiltrate some computer system that controls critical infrastructure, and then lots of people get hurt. I think here too, you're going to find some really interesting disputes ending up in court after, of course, we get through all the IP issues, which you were expert on, among other things.
The other thing I would just maybe jump in and add there is, Section 230 was adopted in 1996. In 2 years, it'll be 30 years old. And yeah, I think as you captured, the theory at the time was that the internet was in its infancy, and this would help create this new technology and, frankly, sector of the economy. And my sense is it may have been the right thing in 1996, and I might argue it probably ceased to be the right thing 5 to 10 years ago. And so there are all of these new questions that have arisen over the last decade, I'll say especially around social media, but now we have yet another new generation of issues, as you captured, with generative AI. And I think a broad group of people look at Section 230 and they say, that kind of immunity just doesn't feel like it's going to lead to the right balance or the right sense of responsibility by companies or the right set of rights for consumers and citizens. And so now when you get to this point, the fundamental question is, what do you do? And the truth is, Congress, having created Section 230, is far and away in the best position to change Section 230. And in the absence of congressional action, a lot of pressure is put elsewhere. So you see state legislatures trying to get around it, but it is hard in part because of preemption. You see people bringing cases to judges in courts, but it's hard when you have a statute that is pretty clear on its face. The best course, in my view, will be for a new generation of legislation to emerge from Congress. And one of the challenges we all live with today is a level of gridlock that makes that difficult. Having said that, so far at least, AI has been one of the most bipartisan issues in Washington, D.C. And we'll see if that continues. But one of the interesting indicia of this was a framework for a new statute that was proposed last fall by Josh Hawley on the Republican side and Dick Blumenthal on the Democratic side. You're seeing sort of unusual partners come together. Nothing's going to happen in an election year, but so much work has been established in Washington, D.C., both by the administration and on Capitol Hill, really, by both parties, that I think that there is a greater probability of legislation in, say, 2025 or 2026 on AI than there is on most issues, regardless of the outcome of the elections this year.
Well, on Section 230, of course, watch Congress because there are competing bills to essentially abolish it or modify it, and also watch the Supreme Court and what's coming out this term by the end of June 2024. One of the things that you both talked about really are these potential risks, and I think that's what has everyone unsettled. So let me throw out one which is common in the press, and that's algorithmic bias. And one of the examples often given, and there are many, is Google Gemini AI actually generated non-white figures, images of historical figures like our founding fathers, for example, or a female pope. And so one of the questions comes up is, you started, Brad, was saying AI is just math, but written into and embedded in these algorithms are potential biases. So what do we do about that?
Well, personally, I think that there's two broad things one should think about. The first is, in many fields of law, bias can manifest itself in discrimination that is unlawful. If you discriminate in giving out a mortgage or auto loans or selling a car, or you name it, you violate the law. And I am highly confident, I'll make a prediction, that none of the judges who are involved in the Ninth Circuit are going to have a lot of patience for a defendant that appears before them and says, Your Honor, the algorithm made me do it. People are still accountable for complying with the law. So, in every field of law, people who have these legal responsibilities today need to learn how to deploy AI in a way that tests it, avoids unlawful discriminatory results, and trains their people to continue to use, frankly, their brains before making decisions and not just outsourcing decision-making to computers. And I think the legal system will go to work and do that. I think that in regulatory agencies, there is a need for AI expertise, at the regulatory level. And I do think there'll be this fascinating process that we'll all want to go through together to help, frankly, provide more education and training and awareness, including for the courts and for law firms and the like. And then the other thing I think we can and should do is look for areas of law, especially in the legislative arena, where we can also help reinforce and advance this. I'll give you an example. Facial recognition is an area where early on, there were statistical studies that showed that there was bias, a bias in the sense that there was a higher error rate for women and for people of color. And the one thing to know about that kind of error rate is, in the tech sector, that's a bug. That's a product deficiency. So with the right incentive structure, you can really move, I think, the market to want to reduce that kind of bias. But the market can work only if the products are available for testing on a widespread basis. Think about what auto safety would be like if you didn't have consumer reports able to test all the cars. And so, one of the proposals we developed that we actually took in Olympia, the Washington state capital, was a proposal that was adopted. It's the only state in the country that has a facial recognition law, and it's one of basically the few in the whole world. But a part of this law was a provision that said that Washington state public authorities would not and could not procure facial recognition solutions unless it was available for testing by academics and others. So, I think a lot of this, if you really put together these kinds of pieces, you can't solve every problem that way, but you can move quickly to make a difference.
I think that's a really important point, Brad, because years ago there was a law review article called Law of the Horse. And it was sort of like, do you need a new law for every little itty bitty thing? And it depends on your perspective, but we have a whole panoply of common law that is in play here, whether it's torts, and we have product liability, we have contract, a whole source of things. So it's not as if all of this will go unpoliced, actually.
That's right, and I mean, to Brad's point, it's the common law, but it's also the regulatory law that applies to specialized contexts,
Right.
from critical infrastructure to FDA law. But I want to also maybe use the FDA example to make a point about how complicated this can get. I totally agree that bias is a real risk. We've seen it, and that we ought to treat that as a really important reminder to just use our brains sometimes and not over outsource these models before we fully understand entirely how they work. That said, so imagine the following medical device, which could be nothing more than an app that uses your phone or maybe your smartwatch in a particular way. What it does is it gives you very specific nutritional recommendations that highlights what will be good for you to keep you healthy. Now, on the one hand, it's entirely clear that the FDA should laugh out of town in the application from a company that wants to provide this in a way that does not take account of data, medical data, that is, say, women and men, and folks of different backgrounds, non-binary folks or whatever, to make sure that we don't leave out some important user group that is going to use this. That's one kind of bias. On the other hand, you can imagine how there's a really good case to be made to use all the information we have, including information that might be race-specific, if we want to give the most bespoke and useful nutritional recommendation. So there can be bias in not using certain data, there can be bias in using certain data, right? And to me, that highlights how all human processes, how to run an organization, how to decide a case, they all involve judgments about what information to use and not use, and in what context it's appropriate, right? So to my mind, we have to disaggregate this bias problem and ask the second order question of what information do we think is relevant and appropriate for what decision-making context?
Let me move that just a little bit differently, and that is, obviously, we've looked at a major risk here, which is the algorithmic bias. I want to look at a more physical risk. What if you can use an AI model to basically produce a dangerous biological weapon, which is not what the model was created for, or a chemical weapon?
Yes, indeed. And I think so one way to unpack that is there's now an initial generation of research on this that suggests that, yes, the utility of generative models, it plausibly makes them sort of tools that are relevant in the biospace, but that at this moment in their development, if you take frontier generative models, the most sophisticated ones, you're not likely to get too much of an advantage over, say, what you might do with an undergraduate degree in biology, searching for stuff on the internet, figuring out what contractors to outsource processes out to if you need to do some kind of DNA synthesis. I think what keeps those of us who care about this space up at night is the speed of the development of this technology. Not where we are now, but where we're going to be in 1 or 2 generations. So let's say GPT-6 or whatever that model might be. And how confident we can be that if those models are limited in their utility because they have very carefully engineered guardrails, that you can't do some kind of prompt engineering to get around that. Or if the technology is open source, that someone cannot use pretty straightforward training methods to gradually build down those guardrails without losing the functionality. 2 more points on this, just very briefly. Probably the right way to think about it is the following. All of us know something about biology, but not that much. A very tiny handful of people around the world have the kind of knowledge necessary to sort of map out how you would engineer a pox virus that would spread much more quickly than natural pox viruses, so that you get infected before you have any symptoms, and where you jack up the lethality so that it is much more universal. The handful of people who have that knowledge and who have the equipment to do that is limited enough that you can partly trust their own judgment and how much they're under some degree of social supervision, as it were. They have colleagues, they work in an organization, that there isn't that much to fear. But these models will extend the number of people who can use the models to then close the knowledge gap. And as you go from hundreds to tens of thousands potentially, this does require a little bit of speculation, but not that much. then you get into some real threats. Right?
Well, you're talking about both speed and numbers, and so I want to ask Brad, I know you've talked about AI as both a tool and a weapon, and there's even been some talk by some in the sector that there should be a, quote, pause in AI while we stop and figure it out. So I'd like to hear from you, Brad, about your sense about the weaponization of AI.
Well, unfortunately, the history of every technology is that it is used as both a tool and a weapon. And as enthusiastic as I am about the printing press and all of the good things that the advance of knowledge has done for the world, it also made it possible for a man in a prison to write Mein Kampf. And that is the history of humanity. And so when you put it in those terms, I think it does force one to really think seriously about how to try to protect against the problems that would concern us the most. And even the question that you asked, what are the risks? That's an important exercise that is advancing and needs to continue to advance around the world. So we all are grounded in an understanding of what are the things that could most go wrong and could cause the most harm. But I think it also forces us, frankly, to then take real action to try to address that. And there's two things to think about here. I mean, one is how you build guardrails. The other is how you put in place some level of, call it, user responsibilities or controls. And then how do you reinforce that with law? That's sort of the exercise here. And to just take another example, you could go to ChatGPT and somebody could ask, help me build a bomb to blow up my school next week. That's a real scenario. And so the guardrails, just to take 60 seconds on sort of the technology of how it works, fundamentally it introduces three terms of art, if you will. The first is what you call a classifier. You create a class of prompts or questions, and you try to then capture all the variants on it. So you create a classifier. We do this at Microsoft. We want to catch all of the prompts that involve somebody trying to build a bomb. Then you connect that classifier once you feel you can identify all of those prompts with what we call a meta prompt. And what the meta prompt does is it intercepts what the model would produce and instead gives a different answer to a user. The answer will be, I'm sorry, I will not do that for you, or that's unlawful. And this is really important in a wide variety of areas. You get teens asking how to commit suicide, and you want to redirect them to counseling and care. So you have the classifiers, the meta prompts, and then what you have to protect against is what's called jailbreaking. Jailbreaking is when you have people who are trying to find their way around that by coming up with some different way of wording it and engineering the model to do what you are trying to prevent it being used to do. And right now, and there's a reason the White House brought in Microsoft, OpenAI, Google, and Anthropic. They had a sense here were 4 companies that were working hard to create this technology. But ultimately, I think we all unfortunately recognize that without some legal floor, there will be some bad actors or people who are just not thinking that will just descend to the bottom and not try to put in place that kind of responsible approach. Then you have the second concept that's emerging rapidly around customers. And it really comes, I think, principally from the world of financial services, know your customer requirements. And so, there is a growing sense that there are many scenarios where the companies that offer these services are going to want to and even be required to put in certain know your customer requirements so that if we do see someone trying to do something like build a biological weapon or a bomb, we can determine who it is. And then the authorities can get involved. There can be reporting, just as there has been with KYC requirements for banking since the 1970s. And so this new legal field that is emerging, among other things, has all of these pieces that are rapidly becoming a part of it.
You had mentioned some state law, and Washington just passed a new law, actually, that criminalizes deep fake porn. So that's where you could take somebody famous or somebody not famous. You could take a teenager, and it appears to be the teenager engaged in porn, or maybe they would take my voice and make it say something that I didn't want. So because there's not a national law on a lot of this, do you think we're going to see more and more of this overlapping state regulation where they step in and say, this is a problem, and Washington, which has always been quite progressive, wants to step out and protect its citizens?
Of course, I think it would be my answer. I think Brad was being exceptionally diplomatic when he referred to gridlock.
Yeah.
Did it with a really nice form of words, which, look, I know legislating is difficult. I also think it's worth remembering that when Madison was writing his portion of the Federalist Papers, he pointed out that it was actually a feature, not a bug. So we'd say in Silicon Valley, to slow down the legislative process and make legislative change difficult. I get that. I also think, however, there's a real question about whether the optimal legislature would be a little more able at the federal level to just get into these issues. Brad's right that there's something unusual and interesting about the potential for collaboration across parties on AI issues, and possible that we'll end up with something sensible. But it's also true that on all kinds of things, New York, Massachusetts, Florida, Texas, California, Washington State, often in ways that diverge from each other, lead into the kind of laboratories of democracy. And I see that happening here. So you mentioned some Washington State laws. In California, you have the state senators trying to set, some of these baselines that Brad was referring to. Sometimes, ironically, this shows you how interesting the Senate law is right now. Building a bit on a White House executive order. So you've got a state in the west of the United States taking these parameters about sort of what models need to be sort of the basis of some notification to government, what needs to be tested before it's deployed, and trying to build that into a state law. Recognizing that just as sometimes the EU from Brussels has this outside effect globally, for better or not, California sometimes has this kind of Sacramento effect, where you set a standard, you've seen this a lot on climate change, and it begins to have an effect more broadly. Here again, the climate analogy is interesting. If you want to understand how it is that China has been driving massive growth in electric vehicle development, use, sales, it modeled the law after California, and it's not perfect, but it highlights that these state level conversations can end up playing out globally. That's why actually my organization now has an office in the West Coast to track this kind of activity.
Well, I want to get to some questions, but I do have one last question for Brad, having grown up through the legal side of things, and that has to do with copyright. We just saw recently Tennessee, which is Nashville's home of country music, passed a law in order to protect its performers and basically limit the use of AI. So the question we often hear is, with AI, is it the end of copyright? What do you think, Brad?
No, the first thing that I think one should reflect upon is that copyright, perhaps as much as almost any legal field, has constantly been evolving to adapt to new technology. Going back to, I think the original copyright statute was the so-called Statute of Anne in England in 1688. And, every new invention really tends to require some change in the copyright law. I would say at its heart, to ensure that there remains a healthy balance between the incentives needed for people to create content and the ability of the public to consume it. And I got my start in the tech sector doing legal work around the counterfeiting of CDs and the piracy of software applications. And the law adapted, and we saw rental rights and a whole slew of new things. We're likely to see this again. And I think we're interestingly seeing a couple of things emerge that perhaps are not surprising. First, you'll see a state like Tennessee, which has such an important creative community, act quickly to protect the interests of that creative community. Sort of almost on the opposite end of the spectrum, you have a country like Japan, where the population is declining by about 1% a year. where the population is aging, where there's just this urgent need for advances in productivity to sustain standards of living and even the human health. And they're going the other way. They're saying, no, we want to make sure that AI can advance as quickly as possible and the results can be disseminated as broadly as possible. Ultimately, certain steps are going to be needed. I think a lot of this comes down to a pretty simple question. If you write a book, does the creator of an AI model that wants to train the next generation of model on your book need your permission? And the argument pro is, hey, this is a copyrighted work, and there's some restricted acts, so you need my permission. I wrote a book. The argument against it is, well, I literally had a conversation with the Chancellor of Germany a month ago, and he said, I think I've read 5,000 books in my lifetime, and I get to remember everything I read, and I don't need to go get a second, copyright permission. And so there's an argument that fundamentally the right to read and learn is not something that requires that kind of permission. Now, there's three ways to sort this out. One is a new generation of legislation. That may happen. It's happening in certain countries. The second is in the courts. Already these cases are being filed. The Second Circuit is probably seeing more of them than anywhere else right now, in part because you just got the book publishers in New York. And the third is you can start to hammer out an arrangement in the marketplace. And I think, there's room for all three. It's never only one. I think we tend to favor some innovation in the marketplace. So there is an easy way for people who want to grant permission or withhold permission to express their views. You can clear the market that way. I think, frankly, there's a piece of this where, some people start out, perhaps including some of the major newspapers, thinking that, oh my gosh, we have content that is so valuable that the next generation of model can't possibly be created without it. Then you realize that actually, if you're talking about the events of the world, there are so many people who write about it that may not be as valuable, interestingly enough, as a very focused academic publisher that has barely been scraping by. And so part of what will shake out of all of this, in my view, is, some people are going to be pleasantly surprised and some people are going to be disappointed, with the value of what they've created. And there will be opportunities for people one way or another to come together. There was an interesting book, I'll just say, written a few months ago called Who Owns This Sentence? Great question. But what it captures is sort of 300 years of copyright constantly changing because of technology. It's inconceivable to me that suddenly we get to 2024 and copyright will stop changing.
Well, that may be a good place to transition to some questions. I mean, obviously, technology and copyright have been intertwined, from statute of Anne to player piano to phonograph records to chips and on, software. Back in the 80s, everyone wondered, I wonder if software is copyrighted. So we'll continue this kind of intersection between technology, I think, and the copyright law. And I don't think there's going to be any answers soon. I think we have time for a few questions, and we have some microphones. So if you have a question, just raise your hand. And yes.
I'd like to know why, let's go back hack. Why did you say hack? Can you repeat the question?
Yeah, I couldn't quite hear the question.
Why did USA hack Seymour for my name?
Okay, so why did the USA hack?
Seymour.
Yeah.
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 You're talking about the clinic?
Oh, and is that a clinic local in Seattle? Okay, maybe that's why I'm not as familiar with it. So I don't know if our panelists have any particular information on that, but maybe happy to talk with you afterwards.
Does AI ever get a First Amendment freedom of speech right?
I think it's gonna be a hard argument to make across the board, but I think.
So let me just say, in case our video people didn't hear, does AI ever get a First Amendment speech right is the question.
Yeah, that's a great question. This is not my area of expertise, but I follow it with, some extra distance. I'm curious if Brad has any thoughts. I guess, can I imagine situations where somebody says, look, I'm speaking through this model? Sure. Would that apply across the board to any instantiation of AI? Probably not. So depends on the circumstance. I think the better case example might be somebody who has a very clear sort of traditional First Amendment purpose and where there's sort of a context that has historically been one protected in a First Amendment situation.
Brad, do you have any thoughts on that?
Yeah, I agree with Tino. First of all, I would say, in my view, the Constitution and the First Amendment were crafted to give rights to people, not to products. And I think that's probably a pretty good approach to continue to follow. And I think an early indicator of what could emerge will be not perhaps initially with the First Amendment, but it's really the patentability rights under the Constitution and under the patent statute. And this is where the Patent and Trademark Office last year started a process to ask the question whether an invention that was created by artificial intelligence could qualify for patent protection. And we put in comments as a company, and I think that we joined many people in basically saying about the same thing, which is AI should be a tool that people should be able to use to enhance their ingenuity, the novelty of what they're creating. But there needs to be some spark of human creativity or ingenuity to produce that novelty and not AI alone. Look, someday people may look at all of us and regard us as antiquated a century or two from now. But I think for our space and time, making sure this technology serves people and is used in ways that protects the rights of people, I would much rather do that than giving rights to the technology itself.
I was just going to say the other context where the First Amendment stuff might come up in connection with AI is in the distribution of information about models. So if you can imagine a scenario where in the future, for national security reasons, the government felt like there were real concerns about releasing to the public certain kinds of details about certain models. I could imagine some people making the argument that they are releasing that information in exercise of their First Amendment rights. The government would probably then point to precedents from the nuclear context where that kind of distribution is conditioned.
When you think back to national security issues when you get into something like that. Anybody else have a question?
Yeah, imagine that you have one person from China sitting on one side of you and one person from Russia sitting on the other, who are also very conversant with this.
These days, that partnership has no limits, so nothing can come between them.
I think people think about pandemics coming from places or space race. What would the conversation be like with these two people on either side of it who have no interest in human rights, who really want to control their populations, and who would like to best Western countries?
So the question is, if you had two people sitting on either side of you, Russia and China, with the premise that they were not interested in human rights, what would be the conversation if basically they had no interest in merging in any way with some of the Western values?
That is a really great question, and it's one that keeps my colleagues at Carnegie and I quite engaged. I'll just share a little bit about this, but it's a longer conversation. On the Russia side, it's quite clear that Russia is very interested in whatever sophisticated technology it can get and the military applications of it. They also have a set of economic concerns about their own tech sector. They certainly want to control their own population. There's a long history in that country of using a whole bunch of techniques to control the population, short of really sophisticated, use of data and information. In addition, I would say their economic model is, not to say there isn't some military industrial complex in Russia, there is, but the core of their economic model is exploiting a very, very massive base of natural resources. It gives them a current account surplus now, even despite the sanctions. China, it's a different picture. They have made it a huge priority to be at the forefront of AI and believe that it's possible for them to be so. But I don't think that means US and Chinese interests always diverge. And in particular, one of the topics we touched on, which is the bigger and deeper safety questions that might arise from really nefarious use of frontier models to do things like develop biological weapons or potentially target critical infrastructure. I guess in the quiet conversations that we've been able to have with scientists and others that are Chinese, the sense we get is that there is interest in China also in figuring out what are best practices to try to limit those kinds of risks. So I think a major question that will drive the future of AI policy globally in the next few years will be, despite many, many areas where the US and China have divergent values, compete, have really different worldviews, and understandably so, is there enough, if you draw the Venn diagram, for them to occasionally collaborate on some of the safety questions around that?
I think we have one question about
I
internet.
wanted to say
Oh,
something.
Brad, I'm sorry, yeah.
Oh yeah, let me just be brief. I'm Tino, you put it very well. I'll just say, I'm very worried about Russia right now. It's probably the leading exporter of deep fakes, including in political processes on public policy issues and probably in elections in different countries this year, as well as, interestingly enough, around the Olympics, because they're not able to participate in it. And they try to use the applications, open source or otherwise, on the market to spread deep fakes. And China, the one thing I would add to what Tino said is, they just have a different philosophy about the use of technology to sort of say manage the population, especially with this enormous reliance on facial recognition and social credits and so many other things. And if you read the Washington statute to protect, among other things, people's First Amendment rights, from, say, government use of facial recognition, that is really the opposite of what is happening in China. And so, what it fundamentally causes one to do, if you think about it, like as we have as a company, is said, there are certain things we won't do in China or anywhere, around, say, the use of facial recognition in ways that would undermine the exercise of free expression. So there are some areas where I think, as Tino said, you can find some common ground globally, and then there are other areas where you realize that people do not think about this the same way.
Yes, there's a question from our online participants. How do you see AI being incorporated into the practice of law and judicial decision making?
Carefully. Oh, what a great question. I'm very curious to hear Brad's thoughts and Judge McKeown, your thoughts. But I would say, look, I'll go back to where I started. I love my current job, but one of the things I miss working on is access to justice, that doesn't come up quite so much in my day job, although we have a research center in India that works on some of these questions a little bit. So I would say the place where I hope it will be incorporated prudently is in helping pro se litigants manage a giant and complicated court system. I would be the first to note that there are some complexities there, because there is a reason why we always hope and expect in an ideal world on any meaningful case a human being would have another human being representing them. But I just would say here, my pitch to you all would be, don't let the perfect be the enemy of the good. And when I see states like Utah that have been doing some experimenting around this, I feel like there's a real access to justice gap that can be meaningfully addressed. And somewhere in between that and the really hard judgments you have to do in a tough statutory interpretation case, where the stakes are whether somebody stays in prison another 10 years or not, I would say a line exists. And to my mind, on one side of the line is the reality that even if the technology gets better enough for us to feel confident that the answer it might give on a bar exam question would give it the kind of insight that might be helpful to you as a supplement to a law clerk. The deeper issue is not that. It's that if somebody is going to stay in prison for 10 more years, there ought to be some human being that has to take responsibility for that. That's in my mind. And that gets me into a really interesting territory. It's all of us, because there are plenty of economists who study the labor market who would say, look, the better outcome is this technology gets good enough to do some tasks that take up 2/3 of a person's job, is for humans to depend on it as a support that increases their productivity rather than statistically. I kind of agree with that in principle, I do, but what exactly does that mean at the level of the user interface design? And how do you basically create in these models features that will create the optimal degree of distrust in them? Does that make sense, right? Like you want them to help you get your job done more quickly on a routine, this or that case, and it's not going to take too much of your time, without making it easy for you to slip into a pattern where you feel like it actually can do the job. And I think that is going to take us to an awkward space where we're going to be in for at least 5 years. I suspect a piece of that will be that any largish organization, law firms or courts, should have a few people who are experimenting with it, but a few people who are not using it at all as a benchmark.
Brad, do you have any thoughts on that?
I think that there will probably be very few areas of legal practice that will go untouched by the impact of AI. And we're in very early stages. I would definitely start with where Tino left off, that we should always remember that most people that have a legal challenge or problem don't have access to a lawyer. It's just so easy to forget whether you're a pro se litigant or just somebody who thinks maybe I should have a will, but I don't really have the means and I'm not really comfortable finding a lawyer. So, I think it can reduce the barriers to entry. And I would not want, I don't think we want AI to engage in malpractice, but we want AI to be a tool that makes the law more accessible and legal services more accessible. And then if you get into the practice of law, look, when I started at Covington and Burling 35 years ago, I mean, my first assignment on day one was go down to a file room and use a tape recorder to record summaries of 10,000 pages of documents. And so litigation has long required the analysis of lots of documents. What I'm struck with today is that it evolved mostly to involve keyword searches. Generative AI, I tend to believe in the next just couple of years will prove far superior to keyword searches in enabling lawyers to find relevant documents. And as a client, I hope it'll be less expensive than current processes. If you then think about what a lot of young lawyers do, they've got to take the documents that pop up and then they read them and they write summaries. My guess is generative AI will do the first drafts, at least, of a lot of those summaries. And if it enables young lawyers to use their minds to do more than read and summarize, hopefully that is a step forward and not a step backwards. It will in some way, I think, impact the work of judges and their chambers and courthouses. I think it's, in my view, a little too early to know, but I'll say the most intriguing conversation I've had on this, and you never know where you're going to meet people that are really innovating, is the Chief Justice of the Supreme Court in Brazil. And so, their court system has about 600 employees, and they're actively running pilots. How can this expedite our calendaring? How can it help us, streamline the work of clerks? How can it reduce the caseload to help people focus more quickly on the issues that are most relevant to the outcome of a case? And there will be times when people will use it to write the first drafts. I think what we've learned is do not let it write the final draft. That's a huge mistake. It's why at Microsoft, we specifically decided to call our technology a co-pilot. It's not an autopilot. It's not a pilot. But it just is one more tool. And, I think the mistake people can make is to think that they no longer have to answer questions themselves. But if they can use it to ask more questions more quickly, then I think it's a tool that can help lawyers reason better. It can help judges learn faster. And that is the promise. And, but if we had this conversation, as we perhaps will in 5 years, I bet there'll be a very rich conversation about all the ways it's being put to use.
Yeah, I think that'll be the case.
So just super briefly, I really like one theme in what Brad said, which is, to my mind, the incredible promise of this technology in the legal sector is to be intentional about it, to figure out what is it that would be a good, thoughtful way of incorporating it, and how do we make sure it doesn't just sort of happen so organically without careful thoughts that then it becomes hard to take a step back and ask what we've lost.
So, I agree with all that, and it's a good last question because most of the people here are lawyers and judges. And what you've heard, of course, is ChatGPT generating some ghost cases that didn't exist. I think that's an aberration. That's not where AI and the legal field is going at all. What Brad is referencing is already there with the new Westlaw and Lexis AI tools, where it can just take a deposition that when we were all young lawyers, we spent days summarizing or looking for. It can create chronologies in seconds. It can even divine human emotions that might be portrayed in a deposition, for example. So I think we're really at the beginning of all this. The Ninth Circuit has created an artificial intelligence committee. Judge Miller is sharing that because we're trying to look ahead. Some judges jumped out immediately without really understanding AI and issued orders like, you may not use AI in my courtroom, which I guess would mean you couldn't use your firm's database, or perhaps you couldn't use Westlaw or Lexis. So I think we're a long ways. It'd be great to come back in 5 years and see where the conversation is, but it will be a tool that will be enormously helpful, I think, in access to justice. And I think it'll be a tool that will be a money saver in many ways for clients, whether they're Microsoft or very small individual clients. But also, I'd like to think, and I don't know that I'll be here when this all happens, I'd like to think that we won't take the judge out of judgment completely, because there is a human factor here that I think is important. So I hope you'll join me, Brad, for tuning in from the Mideast in the middle of the night, Tino coming from California and Washington, D.C. You really have been treated, I think, to two of the top international experts who think about this all the time, even when they're sleeping. So thank you.
Thank you all. See you.